All right, so we're on the record in docket 22-01240 and 24-02906. That is People of the State of Michigan versus Enrique Centeno. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee, appearing on behalf of Enrique Eugene Centeno.
And sir, you are Enrique Eugene Centeno, is that correct?
Yes.
All right, thank you. This is the time set for a forensic review. I know we have of it on the felony file, and then the misdemeanors kind of just tagging along. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we have received an updated report, but that there has been no change in the status, but that we are still hopeful that competency can be restored. I believe we are going to be asking for another control date.
And is that a correct statement, Mr. Lee?
Yes, it is, Your Honor.
All right, this was started as of, on this file on September 26, 2024. And what is the time period for competency in this matter, Mrs. L or Mr. Lee, just so we know that we're setting the control date and how much time we have in order to place the file in the correct hands. If it's gone to, we're trying to set it so we don't go too far.
That's a great question, Your Honor.
Because it's September 24, and this will be September 11, 2025. And I think the statute's about.
Getting close.
Yeah, we're getting close. It's a year or 15 months, I'm not sure. I've kind of, but.
I believe that's correct, Your Honor.
But I don't want to go over the time. And if we set it for control date, I want to know what date we're looking at for the prosecutor's office to make a decision.
Your Honor, can I ask a clarifying question?
Sure.
Does that timeline start from the initial?
It starts from when the original forensic order was signed, which would be the original forensic review on March 21st. Let's see if I can see when I signed the original order. I signed one in May. Appointment was scheduled in March. The very first one. The packet was done by Mr. Goodrich in December.
You sent that order to send them to Forensic Center on 12/17.
So that would be at the 12/17 of 24, right?
Yes.
So that would be the initial prelim. So we've got some time then, you know.
I believe so.
Yeah, because the original order was sent in December of 2024. And we should have at least a year, if not longer. Some are 15 months, some are a month, depending on the offense. Mr. Lee.
Yeah, at this point, Your Honor, I would concur. I know that the general rule is 1/3, maximum 15 months, so
Right.
I'll defer to the courts.
But let's set it for control date 30 days out. And then you can see the exact date, but I think the 30 days out would give us clearly in October would put us within a year from the date of signature. So I will sign the finding an order of competency on this for this date. Defendant is still found incompetent to stand trial but restorable. I will sign on this date, which is 9/11. We can add that, and we will set a control date. So control date of about 30 days out, you think, just for in that vicinity.
October 17th at 9.
October 17th at 9 a.m. A worst case scenario, we get closer to the date and the party should have a date so that Mrs. L can take it, and because the prosecutor's gonna have to make a decision. May or may not, depending on what happens. But worst case scenario, Mr. Centeno status will have to be reevaluated, I would think. All right. And then the misdemeanor file we'll just place with a control date of the same date, because it's kind of tagging along as we try to figure out what's going on with the felony file. So review. We set this for control date on file 2201-240 for the same date of October 17th at 9 o'clock. All right, so Mr. Centeno, we'll see you here at October 17th at 9 o'clock concerning the control date set for competency review. Anything else for the record? I've signed the finding an order, a recent one of September 11th, based on today's determination. Anything else for the record on either one of these files, Mrs. L?
No, for the people.
Mr. Lee?
No, thank you.
All right, you're all set, Mr. Centeno. Thank you for your appearance today.
Then, Your Honor, we would be ready on the Joaquin Flores case when you are.
Joaquin. That's Mr. I have Mr. Palmer, but you're not Mr. Palmer.
No, Your Honor, we had filed our appearance.
All
We
right.
do have discovery. Perhaps our appearances came in around the same time.
All right.
What, does this court need a substitution?
Yes.
Yeah, we'll probably need a substitution.
That's no problem. I'll get that done.
All right, so we're on the record in docket 2502-621. That is people of the state of Michigan versus Joaquin Flores with appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Good morning, Your Honor. Michael Anderson on behalf of Mr. Flores, who does appear personally to my right.
All right, and you're from the Abood Law Firm, is that correct?
That's correct, Your Honor.
And sir, you are Joaquin Flores, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we are going to be asking for an adjournment on this case. We are going to be asking for about 45 days to do some further investigation and additional negotiations. Both parties are prepared to waive the 21 days today.
Is that a fair statement, Mr. Anderson?
It is, Your Honor.
All right. May I inquire of your client of his waiver of the 21-day rule?
Please.
Mr. Flores, you understand you have a right to preliminary examination within 21 days of her date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You have a right to that probable cause hearing within 21 days of your date of arraignment. It is my understanding it is both sides wish to waive that right to a 21-day, to the prelim in 21 days, have this continue in district court where we'll get a new date outside of that 21-day period. You wouldn't be waiving a right to a prelim in general, just within the 21 days. Is it your wish to waive your right to a prelim within 21 days?
Yes, Your Honor.
Mrs. L, the people also waive their right to a prelim within 21 days.
We do, Your Honor.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we'll reset. We're looking at about over 45 days.
If we can.
Okay,
If
so
possible.
6 weeks, I would think.
October 16th at 9.
October. That's about a month. 9/11 to October 16th. But you have the calendar there and I don't, so.
We could go 10/20, October 24th at 9.
Let's go to October 24th at 9, and then the parties can, since the 21-day rule has been waived, we can, let me know if we need that date or if we have or if we can use an additional date. For 25-02-621, we've adjourned to October 24th at 9 o'clock. The 21-day rule has been waived by both parties. Anything else for the record in this file, Mrs. Allen?
Not for the people.
Mr. Anderson?
No, Judge.
All right, thank you. Mr. Flores, you should be all set. I'll see you on October 24th at 9 o'clock.
Notices for you.
Yeah. Yeah, no problem.
We're ready on Lakeisha Black.
Black.
Were there any changes?
All right, so we're on the record in 24-03-220. That is people of the state of Michigan versus Lakeisha Blackman. Appearances for the record, Mrs. Allen.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder, on behalf of Ms. Blackman, who is present, stands to my right.
And ma'am, you are Lakeisha Blackman, is that correct? Right, thank you. This is the time set for a sentencing in the matter. Is there any additional restitution, Ms. Zell?
Not that I'm aware of.
I
Your
have
Honor.
I have 360. Where does that come from?
It's a really good question.
Just a second.
Because it's not a part of the LPD.
No, I just put the probation amount in the restitution box.
Oh, okay.
I apologize for the
I
error.
do not see any restitution.
Yeah,
in this
this is
file.
Right. All right, so I made that correction. The probation amount is for 12 months probation, which is $360. All right. Ms. Schroeder, have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor.
Any additions, deletions, or corrections?
The only thing I will say is that she is now scheduled for an assessment with MMRS, I believe on the 16th, is that correct? Yes, on the 16th of this month. So she did get that taken care of in terms of getting this set up to be done. I think it may have just taken some time to get that done because of financial concerns.
All right, so, and with that correction or edit
Addition.
to the pre-sentence report or addition.
Yeah, nothing else, Your Honor.
All right. Allocution, Ms. Schroeder.
Thank you, Your Honor. Ms. Blackman is here today. She's She is anxious to be able to take advantage of the programming from the probation department. She was very forthright in terms of talking about wanting to make sure I knew she did get that scheduled with MMRS. She is currently, I think she has her second grandbaby now.
Oh, no, I have 6 grand.
Okay, you just got another.
Brand new ones.
You got 2 brand new ones. I misunderstood, my bad. So she has 2 brand new ones that she has been assisting with taking care of. So she is operating on very little sleep at the moment. As I'm sure, I know I understand that concept. I believe the court does as well. However, she does want to make sure that she takes advantage of the programming and doesn't end back up here with the court. We'd ask the court to adopt the recommendations from the probation department to allow her the opportunity to serve a term of probation, and so that she can continue taking care of her grandbabies and assisting her children with that, as well as complete that complete the assessment for drug and substance abuse. I would just ask the court, because she is very limited on means, to potentially waive as many fines and costs as possible, as well as with regard to the PBTs and drug and alcohol testing, that she is concerned that she's going to have that pile up pretty quick on the money. And I don't know what kind of funding is available. If the court maybe could hold off on that until we get the assessment done, maybe not order that until we have the results of the drug and alcohol assessment. And then potentially probation wants to come back and say, yes, we believe this needs to be added, to give her some more time to maybe save up some money. She is concerned that, and she raised that with me today, that she doesn't want to get violated just because she doesn't have the means. She gets very little. So I'd ask the court for those considerations, as well as to, if it is going to order for the drug and alcohol testing, to direct the probation department maybe to assist her in finding means or some funding if possible. Thank you.
Thank you. Mrs. L, any allocution concerning Ms. Blackman before I ask Ms. Blackman if she has anything to say?
No, Your Honor, we would ask that the recommendation be followed. Thank
All
you.
right, thank you. Ms. Blackman, do you have anything to say to the court before the court passes sentence concerning the judgment of sentence? Okay. All right, this is for a guilty plea on July 10th, 2025, I believe, to use of controlled substance. Let's start out as a possession case. I'm going to follow the recommendation of the judgment of sentence of the pre-sentence investigator. I can help you out on fines and costs, but part of the reason we're here for the PBTs in your analysis is it appears that we have to determine it. We have to make a determination if there's a substance abuse problem. Most people come to me with a violation of the probation because they dropped dirty. Okay, I'm being as transparent as I can be. That is what most people, I'd say 70-80% drop dirty. So if that's not an issue, this is your chance to show off. If it is an issue, we need to tackle that issue, because I'm not concerned about Ms. Blackman in the next year. I'm concerned about Ms. Blackman 3 years from now, when you have to make real difficult decisions and you've got people who care about you and you have loved ones and grandchildren, and we have to make sure we get it right now. So use this as a resource. I understand financially it may be a difficulty, and we can help with that, but having a controlled use is not the way to start this. Okay, that's a 1-year misdemeanor, which is not the way to start our path in the future on this. So I'll adopt the recommendation. We'll spend 22 days in jail, credits given for 22 days previously served. I'll set fines and costs, fines at $100, cost at $100, for a grand total of $200. Crime victims' rights fee of $75, state minimum cost fee of $50, set on probation for $30, $30 a month for 12 months. And I'll get you I'll get you a full total on that. So 200 plus 125 plus 360 is 685, can be paid over the course of probation. be placed on probation for 12 months via Zoom. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, and submit to random PBTs and or urinalysis as directed and pay fees. That generally is what trips people up, okay? And then we'll go from there. That's a technical violation. No bars or nightclubs is a good idea. I think the probation officer will be Mr. Sumter, and complete following rehabilitative services, pay fees, and provide proof of completion, a substance abuse assessment within 30 days, which has already been done, or that has already been scheduled, and follow any recommendations of that assessment will be followed, obtain and maintain employment, and not purchase or possess firearms, ammunition, or weapons of any kind. So really, this has to do, the bottom line is substance abuse, all right? And that's going to be an everyday fight. Okay, there's no shame in that. It's just an everyday vigilant fight that you may or may not be a part of at this point in time. But we're going to find out. Okay, we're going to find out. All right. Anything else for the record in 2403-220, Ms. Schroeder?
I guess I would ask the court if it comes down to making payments toward the 685 or doing testing, the court would prefer testing.
I prefer
Okay.
testing, yeah.
Okay.
The total for the amount is due at the end of probation, but the testing is really, because that'll trip you up. And then, you know, the testing is going to trip you up. So prioritize the testing. We can always see what's left over, but prioritize the testing, because if that's my fear, is that the majority of probationers come back to me because they tested. All right. So that's a good question. Mrs. L, anything from the judge, anything concerning the judgment sentence?
Not for the people, thank you.
All right, I'll sign it on today's date, which is 9/11. I don't think,
Just because I put
Yeah.
restitution.
We're gonna make it-
information in the wrong place. I didn't want her to get charged restitution in error.
it's a good point.
They're struggling a little bit down in the police department.
All right, so you may want to stop and see how to make sure that you and Mr. Sumter are on the same page as far as probation via Zoom. All right. Okay, perfect. All right, so that's all for the record in docket 2403-220. Ms. Blackman, good luck to you, okay?
Thank you.
Oh, this one, I don't know. this one. If you go downstairs, I got the, it's on the floor. You know what that is?
Yeah.
Okay, yeah,
Who's on this?
thanks.
We can handle both of those really quick. I'm sure there wouldn't be that much objection from those in the room.
All right, Latham, do you have I don't have an attorney on Latham. And Keyshawn Latham.
One second here. That's probably correct. Yep, I do not either. It's my understanding that he would have to make application to the public defender's office, and typically on his files, they are conflicted out.
He actually declined and said he was retaining Mr. Doyle. Mr. Doyle represents him on another file.
Mr. Doyle, you're right here. So I can ask you, as Mr. Latham, have you had any contact with Mr. Latham?
Yes, John, I believe he had a misunderstanding. He is does have to go to the public defender's office first.
All right,
Well, he declined the application at arraignment, so
So-
they haven't done anything.
all right, so let's go on the record on that one.
Sounds good.
All right, so Mr. Latham, we'll call your case. And sir, in the jail post one, you are Keyshawn Latham, is that correct?
Yes, sir.
All right. This is the time set for a probable cause conference on 2502-02633. That is people of the state of Michigan versus Keyshawn Latham. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zello, Assistant Prosecutor for the people.
And sir, you are Keyshawn Latham, is that correct?
Yes, sir.
And you are not represented by counsel today, is that correct?
I don't see nobody right there. No.
But Mr. Doyle is here and he's indicated that you're going to have to apply to the public defender's office so that conflict counsel can be appointed, because I think there is a conflict in this matter. Is that your understanding, Mr. Latham, or is that all new? Is that new news to you?
I didn't know. Yeah, I just thought that he was going to represent me because they asked me if he was going to represent me. I said, yeah.
But I think Mr. Doyle is conflict counsel, but he's got to be appointed through the public defender's office. And I think that's why you'd have to make application to the public defender's office. Is that so? So at the probable cause conference, I would leave this on and then have the public defender's office probably come talk to you. And you're gonna have to make application. It's kind of a misunderstanding that you didn't make application at arraignment, thinking Mr. Doyle was going to represent you. But my understanding is that conflict counsel has to come from a court-appointed counsel, and that would be from the public defender's office. So you're gonna have to fill out an application.
All right, how am I supposed to do that?
But you obviously can't do that while you're incarcerated. So the public defender will be out to see you and take application since you did not apply at arraignment.
All right.
So I'd ask Mr. Palmer, do we just let your office know to go see him?
I think that's how it works.
I think
Yeah.
usually we email the public defender's office, but I'm just making sure.
Yeah, I think so. And then one of our clerks or whatever will do an intake with him
All right.
and submit it, and they'll make application and send him in whatever direction he's supposed to go for representation.
All right. So we will leave this on for prelim for next scheduled date of September 18th at 9 a.m. And then we will email the public defender's office to now go take a financial application or application so that Mr. Latham, at least that'll get the ball rolling to get it started. And then, so the public defender's office will be out to see you. It might take some time after that because this is conflict and there'll be a conflict counsel appointed, but that's where it'll come through. It'll come through the public defender's office. So make sure you answer any of their questions. All right, sir?
Yes, sir.
All right, and we've set this, we've left this on for prelim for September 18th at 9 a.m. All right, the email has been sent. Anything else for the record in 2502-633, Mrs. L?
Not for the people.
All right, Mr. Latham, the public defender's office should be out to see you, and then we'll get the ball rolling concerning your representation. All right, sir?
Yes, sir.
All right, that's all for the record in 2502-633. You're all set, Mr. Latham. And then, sir, are you Zachary Kelly? So raise your hand if you're Zachary Kelly. All right. I can't hear what you're saying, but I can see you. So we might have to have the tablet moved a little closer, or at least repositioned. And Miss Schroeder's, I have Miss Schroeder on that
And I
case.
believe she just stepped.
All right, that's fine. I just want to make sure that was Zachary Kelly because we were kind of guessing.
And then I believe we are ready on Heather Brown, who's appearing via Zoom.
All right,
And I have Maxwell Felix here.
all right. So let's go in Brown and Felix. We'll go Brown first and then Felix. All right, so we're on the record in docket 25-01704 and 25-01941. That is people of the state of Michigan versus Heather Brown. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ellis, Assistant Prosecutor for the people.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Etheridge from the Office of Public Defender on behalf of Ms. Brown for both matters. She should be appearing by video.
And ma'am, you'll have to unmute. You are Heather Brown. Ms. Brown, you'll have to unmute.
Can you hear me?
I can. You are Heather Brown, ma'am?
Yes.
All right,
Not
thank you.
letting-
This is the time set for a probable cause conference. Mrs. L, how are we proceeding?
I'm
Or
sorry.
would you
Your
like to
Honor.
defer?
At this time, I believe that Ms. Brown is still in the process of being screened for drug court. I will defer to Mr. Etheridge for more on that.
Mr. Etheridge.
Yes, Your Honor. We are asking that matter be adjourned again. She's still in the process of getting screened for drug court. She has had some medical issues and still dealing with medical issues to kind of slow the process down. But she still, at this point, would like to have the assessment completed to see if that is a possible option.
I will make note. I'll make note that the waiver of the 21-day rule on file 25-01704 was waived as of June 20th. And then on 25-01941, it was waived as of July 18th. We will, understanding it takes some time for the specialty court to do their screening. That's the time frame we're dealing with, June and July. So I will grant the adjournment for screening for specialty court. And I would think that we would set it so that we have an answer from specialty court within the next, 6 weeks or so?
I hope so.
Yes, Your Honor.
All right, so in that time frame.
What do you want to set for prelim or PCC?
We'll set it for prelim. That might give us more time because we know where it's heading. We just don't. And that mental health, the specialty court, is that 55th?
54B.
54B. So that's Judge Grenwell. All right.
October 30th at 9.
So October 30th at 9. October 30th. All right, Ms. Brown, we've reset this for October 30th at 9 o'clock to continue your screening for 54B specialty court. Anything else for the record? And then you can let us know if that changes in any way. I'll wait to hear from the parties because if it happens before then, and now we can wish for anything, right?
Yeah.
But October 30th at 9 o'clock, we'll set it for a continuation to see the specialty court screening process. Anything else for the record in 25-01941 or 25-01704? Mrs. L.
Not the people.
Mr. Etheridge.
Just to clarify, those are preliminary examination dates.
Those are both preliminary examination.
Thank you.
All right, so Ms. Brown, we'll see you in that October date and continue the screening process for specialty court. All right, ma'am?
Okay.
Thank you. Then Mr. Palmer, did you have Mr. Maxo
Yeah.
or Maxo Felix? All right, so we're on the record in docket 25-02561. That is people of the state of Michigan versus Maxo Felix. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Felix, the gentleman who's standing to my right. Could I have just one quick second? to say
Absolutely.
something, Mrs. Zell? All right, thank you, Your Honor. We're ready. to proceed.
All right, thank you. And sir, you are Maxo Felix?
That's fine.
I have a note here that you were upon release, there was going to be an upgraded address at arraignment. Were you able to do that, sir?
Yes.
Okay. All right, this is the time set for probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we will be leaving this set for preliminary exam.
Is that a fair statement, Mr. Palmer?
That is a fair statement, Your Honor. And there's just one other matter I'd like to address regarding a bond condition.
So we will leave on for September 18th, 2025 at 8:30. And Mr. Palmer, you may address your bond.
Thank you, Your Honor. Mr. Felix is a truck driver by trade. He travels throughout the Midwest. He is currently wearing a GPS tether. My understanding is that one of the conditions within the bond is that he not leave the state of Michigan, which is, as the court knows, is a standard request. I think the GPS also requires that. The issue is that Mr. Felix is unable to work as a result of his inability to leave the state of Michigan. And specifically, he needs to travel to Gary, Indiana to have his truck repaired, which is where the facility where, or the place where they can repair his truck, as I understand it. I would ask that, given that he's already wearing a GPS tether, I would ask that the court consider allowing out-of-state travel for the purposes of employment. Mr. Felix would, of course, still have to comply with all the terms and conditions of bond. He understands that he has to be here for the preliminary examination next week in person. We're not asking to change any of that. We're just asking to change the out-of-state travel requirement.
All right, thank you. I don't have no out-of-state travel as a bond condition, but it wasn't checked. So I don't know.
Let's check OST. Is that what it says?
No, GPS is checked.
So there's,
So I want to check the bond conditions to make sure, because there may not be a no out-of-state
Okay,
travel.
well, I was under the impression that there was.
There usually is.
Right, and there usually is. And so I guess either way, I just want to clarify so that we're all on the same page about what the court's ruling with regards to Mr. Felix.
I have the GPS is checked, nothing else. But that doesn't mean what I have is in the computer.
Totally good.
the computer has a lot of bond conditions.
All right, so let's do, so what are the bond conditions? And then we'll modify for out-of-state travel.
Understood.
GPS tether.
Okay.
No out of state, no alcohol or drug. No out of state travel again, no contact with the victim. Not to possess a firearm and free trial services within 48 hours.
All right, so typical bond conditions, and then we'll modify the no out-of-state travel for employment purposes. All right, so the bond conditions, the boxes just aren't checked. So bond conditions remain the same except for out-of-state travel. So you are allowed to travel out of state for employment purposes. So if you're stopped you should have something indicating that you're working under, that being a truck driver speaks for itself, but it wouldn't hurt to have something, something in writing indicating like a ledger of your hours or something along those lines.
Yeah, it's electronic.
All right. It wouldn't hurt to have the capacity to allow law enforcement to see that, because that could be a problem. Okay. If you're driving an 18-wheeler, it's not going to be a problem. But if you're traveling and you're not, then you're going to answer these questions. Because it is for employment purposes. So out-of-state travel allowed for employment purposes. Did they assign you a pretrial agent, a pretrial services agent?
I think so.
Yeah, I think.
Shelby.
Henson.
Thank you.
All right, that allows us to indicate to him that this has been modified to allow for employment purposes, so that your pretrial services knows, because none of the boxes are checked. All right. All right, so I'm going to grant the motion for employment purposes to travel out of state. We've contacted your pretrial services officer, and we're leaving this on for preliminary examination. That'll be live on the 6th floor of City Hall of Lansing on September 18th at 8:30. Anything else for the record in 2502561, Mrs. L?
Not for the people, thank you.
Mr. Palmer?
No, Your Honor, thank you.
All right, Mr. Felix, we'll see you next week.
I'm gonna have some people for you.
Is Brandon Lee on Zoom?
And then
Yeah.
yes,
Oh,
he's on the iPhone.
Could we just do him real quick? Because I think Judge Simmons is asking for me for.
Yes. And that's Mr. Lee.
Yes, Judge.
So let's rename him.
I'm so sorry about that.
Oh, that's all right. Well, we should play it. It's got the other one come out. So,
They're doing. He's on Zoom.
Mr. Gosser,
Oh, yes.
I'll just.
Yeah.
I just
And
got
then-
across the street, across the hall.
Lee.
Yeah, and then just, if he wants to take it, then we can call
Yeah,
the officer.
I get you. Yeah. We'll just-
All right, Mrs. Zell, are you, on Mr. Leak, should we call both of those files together, or,
I believe we can.
all right. All right, so we're on the record in 25-02635 and 25-02636. That is people of the state of Michigan versus Brandon Leak. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on both files, on behalf of Mr. Leak, who appears today via Zoom.
And sir, you are Brandon Leak, is that correct?
Yes, sir.
Right, thank you. This is the time set for a probable cause conference. Mrs. L., how are we proceeding? Would you like to defer to Mr. Palmer?
Your Honor, I believe we are leaving both of these set for preliminary exam.
Is that a fair statement, Mr. Palmer?
That is accurate, Your Honor. Thank you.
So I will leave both of these on for prelim next week for September 18th at 9 a.m. So that'll be next Thursday at 9 for preliminary examination. Anything else for the record in dockets 25-02635 or 25-02636, Mrs. L.
Not for the people.
Mr. Palmer.
No, Your Honor. Thank you.
All right, Mr. Leak, we'll see you next Thursday. You should be all set, sir.
All right.
Yeah, 1:30 left, I believe. We could do the Tyrion or Tyrion Hickson.
You went back, so.
Yeah. I got
Is that Tyron Hickson?
Yes, Your Honor.
oh,
All right, so we're on the record in docket 25-02616. That is People of the State of Michigan versus Tyron Hickson. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Tyron Hickson.
And sir, you are Tyron Hickson, is that correct? All right, thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we're going to be leaving this after the preliminary exam.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll be leaving on for prelim for September 18th at 8:30. That'll be next Thursday at 8:30 for preliminary examination. Anything else for the record in 25-02616, Mrs. L?
Not for the people.
Mr. Lee?
Nothing further. Thank you.
All right, Mr. Hickson, we'll see you next week. Thank you for your appearance.
All right, let's get you out of here then.
So we have Mr. Kelly
Oh, and we have Mr. Well.
and Mr. Weldon. All
I
right.
believe that is in the bottom. And Miss Ludi is here as well.
And Ms. Ludi. Let's do Kelly
And
first,
Kelly. I don't even know if he's in the valley.
then we'll do Ludi. All right, Mr. Kelly, can you hear me? All right, I have your attorney here. So we're on the record in docket 25-01066. That is People of the State of Michigan versus Zachary Kelly. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Kelly, who appears by the Polycom from the Ingham County Jail.
All right, and I made contact, sir. You are Zachary Kelly, is that correct?
Yes, sir.
Okay, thank you. And I can hear you better now. And before I had him raise his hand because I wasn't sure that was Mr. Kelly. This is the time set for a review hearing, a forensic review hearing. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we have not yet received a report from the Forensic Center on this case. I will defer to Ms. Schroeder.
Ms. Schroeder.
I think we're just gonna have to set this for another review date. I don't even have yet, Your Honor. I see where the order for competency was signed and sent over back in August 15th-ish.
Yes.
I think. And I have not even received information from the Center for Forensic Psychiatry. He's even been set for an appointment. So I don't know if there's something that the court can just prod them because he is in custody. And I know they've had some problems knowing people are actually in custody. There was an issue like a month or two ago with them being able to look that up. So I don't know if there's a way to kind of.
So we'll make sure the Center for Forensic Psychiatry knows that Mr. Kelly is incarcerated, which we'll send him an email to that.
Thank you.
We'll reset the control date. I would think 30 days out just to be safe. So we would have some report from, or at least we'll know if an appointment's been set.
Yes, yes.
All right, we'll set a control date. So the defendant, we're waiting. Evaluation. Order signed on August, I was signed the order on August 14th.
Yes.
And we'll set a control date. For
October 17th at 9:30.
October 17th at 9:30. All right, so control date's been set. At that time, if we still don't have an appointment set, we'll contact the center.
Okay.
I think it's a resources problem for them more than anything, but we want to make sure to get the appointment rolling because Mr. Kelly's incarcerated.
Okay. And just so I'm clear, Your Honor, the court will still just kind of reach out to them today to see.
Yes.
Okay.
Yeah. We'll let them know that Mr. Kelly's incarcerated.
All right. I know I made note of that when I did the referral petition to them, but I know, like I said, I've had several clients where
Right.
they were like, oh, they're out of custody. I'm like, no, they're not. I don't know.
Yeah,
Where you're.
that's been my experience also.
Yes, thank you, Your Honor.
All right, anything else for the record in 25-01066, Mrs. L?
Not for the people.
Ms. Schroeder.
Not the defense.
All right,
Thank you.
Mr. Kelly, you're all set. Thank you for your appearance today. If you have any questions, Ms. Schroeder will be out to see you.
Yep, yes, Your Honor.
And then let's go on, Miss Ludi.
Yes, she is right back here.
That's a sentence.
Yes, Your Honor.
All right, so we're on the record in docket 25-01933. That is people of the state of Michigan versus Aaron, is it Ludi?
Yes.
Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Miss Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder, on behalf of Miss Ludi, who is present, stands to my right.
And ma'am, you are Aaron Lucille Ludi, is that correct?
That's correct.
All right, thank you. This is the time set for a sentencing on the matter. Ms. Zell, is there any other restitution on this matter? I don't see anything in the judgment of sentence.
I do not believe there is any restitution.
All
Your
right.
Honor.
Ms. Schroeder, have you had the opportunity to go through the pre-sentence report with your client?
I have, Your Honor.
Any additions, deletions, or corrections?
No, Your Honor, not as it is written. I have some information to give the court, but I will leave that for elocution. Thank
All
you.
right. Elocution, Ms. Schroeder.
Thank you, Your Honor. Miss Ludi, she understands with regard to the alcohol and drug assessment, the comments there by probation. She did look into getting an assessment done, but when she was trying to get one done, she was quoted a price of $250, which she does not have as somebody who is seeking out Social Security disability and is unemployed at this time and homeless. So she just was not able to complete that. I have spoken with her, and she also, on top of all that, has been having problems with her phone. So, but I did speak with her this morning. I've discussed with her some potential resources such as Crystal Ray that I know used to do like a sliding scale. I don't know if they still do, as well as she indicated she is working through community mental health and is on Medicaid, which I know that community mental health, if you ever open case with them, can also complete substance abuse assessments. So she is already in line to go down there she's done the initial paperwork. She just has to go in and do now the official intake, which is a walk-in situation. And she's going to be progressing toward that today because she needs their assistance with some Social Security questions. So I believe that we're going to get that taken care of today and getting something set up. And this is purely just a resource in terms of money situation. Why that didn't get done, it was not for lack of wanting. It's just not the resources to be able to do it. She wishes to take advantage of the opportunity of having this kept off her public records. We'd ask the court to adopt the recommendation for the 7411 programming. She is hopeful once she's able to get things lined up with community mental health, as well as with Social Security, that she will be in a better position financially to make sure she takes care of her obligations to the court. I would ask the recommendation be adopted. I do believe she wants to do what is necessary to take care of this and learn from it. And as such, she'd ask the court to allow for that. I'd ask for any fines or costs to be waived to the greatest extent of the court, so that she can concentrate on paying for testing, which I am sure is going to be ordered because of the nature of the offense that she pled guilty to. And so that she can focus on that and make sure that she's successful. Thank you.
Thank you. Mrs. L, anything you'd like to say before the court asks Miss Ludi if she has anything to say to the court from the people?
Thank you, Your Honor. We would ask that the recommendation be followed. We would also encourage that assessment be done so that probation has a better idea of how to help Ms. Ludi moving forward for those services. Thank you.
Thank you. Ms. Ludi, is there anything you'd like to say to the court before the court passes?
I think mostly that's it. I just want to really focus on treatment. I'm willing to do treatment too. And just focus on getting this up back to.
All right.
That's important to me. So.
Essentially, the whole purpose for probation is treatment, okay? But we understand there's financial concerns. And so any probation I'm going to follow the judgment of sentence, place you on probation for 10 months. What that really means, though, is that I'm involved for 10 months, okay? You have a probation officer, and and really what people come in front of me more, they violate the probation because they drop dirt, okay? And so if that's not the case, this is your time to shine. If that is the case, we need to find that out now. And we have to start to attempt to work on it, okay? That's the whole purpose of district court, as in the way I see it. And so use this as a resource, because I'm not, for the next 10 months, you're on probation to me. But I'm really concerned about Ms. Ludi in the next 10 years from now, when you have to make good decisions concerning any aspects of this. And you want to have a positive relationship with controlled substance, not a negative relationship with them, or none at all, depending, okay? So this is for a guilty plea on July 11th for the use of cocaine misdemeanor, 1-year misdemeanor. It is ordered the court, you spend 180 days in jail, credits given for 2 days previously served. I'm going to suspend 178 days. So it's all no upfront jail, it's all probation. I'm going to set fines and costs. Fines at $100, costs of $100 for a total of $200. This one we will print out because it's got to be made pretty. Crime victims' rights fee of $75. State minimum cost fee of $50. I'm going to place you on 10 months probation at $30 a month for a total of $300. And then I will give you a grand total for that. But Ms. Schroeder is right. So that's a total of $625. The 7411 is granted. That's kind of the good part of this, okay? Because it means it's abstracted differently. If you violate probation, that's most likely the first thing to be taken away. Okay, just being as transparent as possible. The violation of probation takes away the 7411 status, usually. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance, submit to random PBTs, enter urinalysis as directed by Jody Bayless, will be your probation officer, and no bars or nightclubs. The complete following rehabilitative services, pay fees, and provide proof of completion to the court. There should be a substance abuse assessment. We've talked about that. You're in the works of doing that. And then follow the recommendations of any mental health recommendations. You're going to have to sign a release to your probation officer so they can be somewhat involved in making sure that you're following those directions. Obtain and maintain employment and not purchase, possess, or firearms, ammunition, or weapons of any kind over the 10 months that you're on probation. Do you have any questions concerning the judgment of sentence, Ms. Louie?
Just as far as the employment, and like she stated before, I'm going to be working with CMH to try to help me get that process moving, but I have a pending application. I don't know about how that's going to affect.
Yeah, I would think that I've never seen anybody violated for employment purposes.
Okay.
So realistically, as long as you're working towards that goal, you should be fine.
Okay. And that's another thing, they can correspond CMH with the disability.
Correct. Correct. Absolutely. And if CMH recognizes the disability and then that paperwork's done, that cures any obtaining and maintaining employment. Okay. All right. All right. Any other questions, Ms. Ludi? That was a good question.
I think so.
All right. All right. I'm going to sign. We're going to reprint this because somebody's got to read my writing, and I don't envy that person. You probably should go down and speak with Ms. Bayless, or at least understand the nature of the Zoom relationship. It's 10 months via Zoom, or at least get on the same page at some point with her to make sure, because that is a person who would violate, okay? Would be Ms. Bayless. Anything else for the record in 2501933, Mrs. L?
Not for the people, thank you.
Ms. Schroeder.
Now for the defense, thank you.
Right, let's check that. I'm sure it's not- I don't think that's how she spells her name. All right, you're all set, ma'am. Thank you for your appearance today.
Thank you. Take care. You probably should just go and check in too.
Check in with bailiff.
Yeah, they may see you, they may not, so you
Yeah.
should be fine.
He's done on the 5th floor.
Okay.
Thank you so much. You're welcome.
Wild man on
Yep.
Holly.
Yep. Yes, if the court is ready for that, I.
Yeah,
It's-
we are ready.
Oh.
All right.
Shoot. Gosh, I think we're getting to that point.
I think we are. Don't know how much longer.
That's, yeah, because it's.
Yeah, that's, I mean, that's my concern.
1/3 of the maximum possible penalty, but he.
All right, so here is.
Did he plead already? No, oh, that's right. Yeah, I'm sorry. I'm having a
No,
minute.
Mr. Wellman.
Thirds and I are not, so I think probably within the next 2 months. He's gonna. If I'm doing math right.
I think so, so maybe we set it for October.
Yeah, and then if we still don't have anything, then.
And
My office makes a decision.
Yeah, all right, we'll put that on the record already.
all right, so this is for Mr. Darcy Wildman. So we're on the record in docket 25-00156. Appearances for the record. This is People of the State of Michigan versus Darcy Wildman, set for forensic review today. Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Wildman. And he appears from the Ingham County Jail. I'm here in person.
All right, thank you. And sir, you are Darcy Wildman, is that correct?
Yes, sir.
Thank you. This is the time set for a forensic review hearing. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that there has been no change in the status of this case. Before going on the record, me and defense counsel were discussing the timeline for this. The people believe we have about 8 months to get Mr. Wildman restorable, or that 15 months at maximum. That 8 months, we believe, is that 1/3 of the potential penalty. At this time, we would ask for this to be set for another control date in sometime in October to see if that restorability is possible.
Thank you. Is that your understanding, Ms. Schroeder, and anything you want to do to supplement the record?
So, yes, Your Honor, yes, that is the conversation that myself and Mrs. L have had today. I am looking at the finding order on competency dated March 6th of this year, 2025. I believe my understanding from the statute is it's 1/3 of the maximum possible penalty or 15 months, whichever is the lesser timeline. So we'd be looking at the 1/3 here on a 2-year maximum for the RNO, the resisting obstructing. So I believe 8 months is correct. With regard to that, so if we, we get into November, pretty much November 6th, if my math is correct, is probably our due date essentially. So I would ask that, yes, we get back here mid-October at the latest to see if anything has changed, because I think at that point a decision has to be made.
All right, and we're working, that is the finding an order of competency was signed on March 6th. Is that correct?
Yeah, is what
That's the one you're looking at?
That is the one I'm looking at, Your Honor.
All right, I'm gonna sign one for today's date, but we will reset. We'll adjourn for, we should not say adjourn for a control date. And if we set it in October, that'll give us a few weeks for the prosecutor's office to make a decision if we don't have an answer at that time. I think that's a fair statement.
That is, Your Honor, and I do plan on going back to my office and having that conversation starting now to make sure we have some sort of idea on how to move forward.
So adjourn for control date in October of?
October 17th at 9:30.
October 17th at 9:30. I will sign the new order, but of course, we're still working under.
October 17th at what time?
October 17th at 9:30.
Thank you.
All right, so Mr. Wellman, your attorney, Ms. Schroeder, will be the to see you. We've set this for a control date of October 17th at 9:30. If we don't have an answer to our question for competency, the prosecutor's office at that time will make a decision. But that'll be on October 17th at 9:30.
When will I see the attorney?
Ms. Schroeder, sometime in the next week.
Yes, I will make a point of talking to him here in the next week. There just haven't been any updates, unfortunately.
Right. Yeah, we're still waiting for some report, I would imagine.
Well, we've gotten if I may, Your Honor, we've
Yeah.
gotten reports that continue to find him as being not competent to proceed, but no plan and no restoration.
And for the record, that is true. The last report received was from September 2nd. That's the last report I have.
Yes, that is what I have as well, Your Honor.
All right. With that understanding, that's all for the record in 24-00156. Thank you for your appearance today, Mr. Weldon.
How ridiculous.
I think it either has to be.
I'm ready to come out.
Oh, good. All right, we will call the AG case. Mr. Trescone is here on the AG case. And Ms. Johnson.
Good morning, Judge.
And Ms. Dwyer, you're the attorney for Mr. Cunningham. Is that correct?
That's correct, Your Honor.
All right.
Your Honor,
And
I'm sorry.
go ahead, ma'am.
So as I say briefly before we go on the record, I'll be requesting to waive Mr. Cunningham's presence. He is currently in the hospital. He got a crazy infection when he spent the overnight at the Lansing County Jail. But while he was in the hospital being treated for sepsis, they discovered some growths on his kidneys and gallbladder. And so he is being treated for that. And I don't know, as soon as possible, we'll be having surgery, I would assume, to have those growths removed. But in any event, I preface this because he's not here today, but this may be an issue for a couple months as we move forward.
All right, Mr. Trescone, is that your understanding?
Yeah, Your Honor. I don't have any problem. I've seen the medical notes. I don't have any issue adjourning this out, 45 days to another PCC just to, as a status check. It's a non-violent offense. It's a tax offense. There's not any huge rush to get him
All right,
adjudicated.
and that's your understanding, Ms. Johnson?
I'm not in the loop with that. I apologize.
All right.
I was here to obtain a tax order if possible.
All right, so this is set for PCC Day. I don't know if we have an appearance, Ms. Dwyer, for Mr. Cunningham. So make sure you file an appearance and a
I'll do that
substitution
again.
of counsel, or just an appearance. All right.
Okay.
Judge, if
All
I
right.
may.
You may. So, let me call the case. So we're on the record in 25-02-557. That is people of the state of Michigan versus John Cunningham. Appearances for the record, Mr. Trescombe.
Michael Trescombe for the people.
And Ms. Johnson.
Denise Johnson, Assistant Attorney General on behalf of the Michigan Department of Treasury.
And Ms. Dwyer on behalf of Mr. Cunningham.
Yes, Your Honor. Lisa Dwyer appearing on behalf of Mr. Cunningham. Good morning, Your Honor.
And Mr. Cunningham, as indicated previously, is not present today. Mr. Trescombe, are you seeking a bench warrant or are you waiving the appearance for Mr. Cunningham?
No, Your Honor, I would waive his appearance.
All right. This is the time set for probable cause conference. Mr. Trescombe, how are we proceeding today?
Your Honor, as we previously discussed, Mr. Cunningham has discovered some pretty serious medical issues. We'd ask for scheduling for the court to adjourn this to, I would say, the end of October, early November for a PCC. There's a couple other bookkeeping matters to address today. Because this is a Treasury case, I have asked Ms. Johnson to file a disclosure motion and order on behalf of Treasury. It's my understanding Ms. Dwyer is willing to stipulate to that. I believe the court should have the proposed order. There also was a protective order for discovery filed, a stipulated protective order for discovery filed. I would ask the court to sign that. And then I have also have my officer in charge, I believe, either on Zoom or in the waiting room. And we are prepared to swear out an amended complaint with a added count 3 that would reference tax, would be the same as counts 1 and 2, but would reference tax year 2023.
All right. I can't do an arraignment today for Mr. Cunningham. That would have to go through, but if
He was arraigned.
What's that?
He has been arraigned, Your Honor.
Right. So the request is for an
Oh, you
additional
mean for
arraignment.
count 3, I see.
Yeah, for today's purposes. And the docket would not allow me to do an arraignment. Also, I would send people's heads spinning because the arraignment would be done by the magistrate or by the arraignment judge on today's date. However, we can make this a part of the preliminary examination, additional counts to be requested for bind over purposes or between Mr. Trescombe and Ms. Dwyer. If it comes to that, that would be the agreement that the parties would reach. If you want to arraign him, we probably should put him in a traditional arraignment setting, would be that he would be arraigned by whoever magistrate or attending judge for that date, on that date. That would be my guess. I'm just guessing at this, that it would be a traditional arraignment to add more counts. That can always be done at prelim with the understanding of a waiver, or that can be done at prelim with a bind over once we have the prelim and a request for bind over. That's completely up to you, Mr. Trescombe, concerning this. But as far as the PCC for today, you'd be requesting a good cause adjournment. Mr. Cunningham is not waiving his 21-day rule since he's essentially not here. And we'd good cause adjournment for a PCC to be set sometime at the end of October or beginning of November. Is that your understanding, Mr. Trescombe?
I guess I think it would be a stipulated adjournment at this point. I don't want the request to be on the state. It is Mr. Cunningham's medical problems that are the reason for the adjournment. And I don't see why his attorney couldn't waive the 21 days for him since he is indisposed.
my problem is with this is that Mr. Cunningham would be the person I speak to concerning the waiver of the 21-day rule. And Ms. Dwyer, although representing Mr. Cunningham, he would, for my purposes, that would not suffice. I have to hear it from the defendant's mouth that he is waiving a 21-day rule, or we can leave it on for prelim next week. But I'd like to hear from Mr. Cunningham that he's waiving the 21-day rule. Otherwise, this is good cause. If he's in the hospital or he has some health conflicts, this is good cause for adjournment.
And I guess then if that's where we are, then I guess I would ask the court to find good cause for the adjournment.
All right. So my understanding is that the request will be for a good cause adjournment. Mr. Cunningham would not be waiving any of his rights in this matter. And we would adjourn for an additional PCC.
However, I am unavailable the end of October and early November. I apologize. I'm in two different trials back to back.
Right. Well, we can make it sooner than that because this is a good cause adjournment.
Right.
We can make it we can make it as soon as possible.
I could do it the
or we
week
can
of the
just leave it
20th.
on for next week.
Yeah, he won't be available next week. I'm asking can we do the week of the 20th of October is what I'd ask. If you
I think that's what we're scheduling right now.
Okay, great.
Let me see.
We can do October 23rd.
We can do October 23rd at 8:30.
Thank you.
Okay. So we'll set for October 23rd at 8:30. I will indicate that I have signed the protective order for confidentiality of discovery material. I've signed that stipulation on September 5th, it looks like. And then the order permitting disclosure of taxpayer information, I'll sign on today's date. And so if there's any other motions to be filed concerning discovery requests, I can either sign those pursuant to stipulation, or if they're set up for motion, we'll get a motion before the preliminary examination. So we can address the motion before the actual preliminary examination. If it's like this, which is more than a discovery, this is just a discovery issue that's stipulated to, we could probably do a date of preliminary examination, but that should go through my office for notice of hearing. I know every judge does this differently, but that my preference would be to know what the motions are and to see them coming, and then if we have to address them before the preliminary examination, or we can stipulate and have it and have the order signed at the preliminary examination. All these seem to be discovery requests, so they'd obviously be signed once the parties have the information they need for the zealous advocacy of Mr. Cunningham. So I have adjourned this to for PCC for October 23rd at 8:30. Anything else for the record in 2502557, Mr. Trescombe?
Just to clarify, that's a PCC. The court is not resetting an exam date.
Correct. I've set it for PCC, and then we'll probably set it a week from that date. What's the prelim date for the next week? Or we can set it for prelim. It doesn't.
No, that's
it really
fine.
doesn't matter.
I don't
Yeah.
think we need to set a new prelim date. I don't. I just wanted to make sure I had that correct.
Perfect.
I'm more than happy to see where Mr. Cunningham's health is at the end of October. And then you did sign both discovery orders.
Correct. I signed both discovery orders, and that was kind of the plan to see how his health is on that October 23rd date and then set it for prelim if necessary.
Thank you, Judge. Ms. Dwyer, just so you know, my secretary is out until Monday, so I will have discovery to you Tuesday or Wednesday.
Thank you for letting me know. Thank you.
All right, and then Ms.
Thank you, Your
Dwyer
Honor.
will get an appearance on behalf of Mr. Cunningham from your office, and we've
Yes.
set it for October 23rd at 8:30.
Okay. Thank you, Your Honor.
All right, that's all for the record in 2502-557. Thank you, everybody, for your appearance today.
Thank
Thank
you.
you.
Your Honor.
All right, Mrs. L, what case are we calling next?
Your Honor, if we could, I believe we are ready on Corey Goss. And then, is Miss Wanji on Zoom? Yes. Perfect. We would be ready on the Emma Hatch case as well.
Right, so we're on the record in docket 25-01-218. That is People of the State of Michigan versus Corey Goss. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Etheridge.
Well, good morning, Your Honor. Assistant Public Defender Derek Escher, also Public Defender on behalf of Mr. Goss. Mr. Goss is in the courtroom standing to my right. His father and uncle are also in the courtroom in the galley.
All right, sir, you are Corey Goss, is that correct? All right, is that a yes, sir?
Yeah.
Thank you. All right, this is the time set for a sentencing in the matter. Mrs. Zell, is there any further restitution in this matter?
Your Honor, actually, if I could, I believe at this point, we are actually trying to get this transferred over into mental health court in 55th. Mr. Goss has an active file over there that is also heading to mental health court. We are confident that will be done. The delay on that is a failure on my part. I did not get the paperwork in motion for that. Me and Miss Wilson, who is the APA out in 55th right now, will be working on that later today. If we could get a brief adjournment or an adjournment of this sentencing date.
All right, and that's the plan here. The plan is to transfer to 55th Specialty Court. Is that correct, Mr. Etheridge?
Yes, Your Honor. He's already accepted in mental health court. This court accepted the plea. The plan is to have it transferred there and have Judge Hillman do the sentencing. He did pick up another case that is also going to be transferred to mental health court and hopefully be resolved through a package plea offer. That is scheduled, I believe, for the 18th. So I think the prosecutor can have the paperwork done by the 18th. If we just reschedule this for that date, you'll have all this stuff scheduled on one day.
I'm not sure. I'm not sure if that is wishful thinking, but I think Mrs. L has the answers.
I believe we could at least get that paperwork moving by then. The 18th would be
A week from today.
Yeah, I'm seeing that. The only concern is that since it does need the judge's signatures, that might be the delay that we might see.
Right.
It would be my goal to have all of it prepped and ready to be submitted to the courts by tomorrow.
But if you had all the paperwork done by the 18th, I can sign it. And so if you let Ms. Holden know that that's available, we can get over and sign it. We can set it for the 18th for sentencing and then whatever global resolution. Would that suffice?
That would work for us.
Mr. Etheridge?
Yes, Your Honor. I mean, as long as we can get the paperwork and I mean, it doesn't have to be completely processed by the 18th.
Right.
Have it to sign and
Correct. Just in the works of it. All right, so let's adjourn to the 18th is so what date would that be? That's the date set
That
for.
would be next Thursday. May I ask a question?
Sure.
Normally,
This is anything but normally.
I know, I don't believe that once you sentence him, we can transfer the case because the case is disposed. We can transfer the probation oversight to 55th, but I don't think we can do a true transfer. If you sentence him, if he's sentenced in the specialty court, that makes it a difference somehow. I don't know how, but it does.
That would make sense because once he's sentenced, unless the sentence sentences him to, I'm avoiding the bureaucratic nature of if it is sentenced here, then that would resolve the case here. And we don't want it resolved. We want it set to 55th.
So the goal is to have it transferred and have sentencing there. Would waive any right to have you sentence him. Since you took the plea, we'll waive that right and have Judge Hillman sentencing.
That would make more sense.
That was what my understanding
Yeah,
was.
that's okay.
Just withdraw the plea altogether here and just send the whole case over. He can withdraw his plea here if he's accepted in mental health court. And then we can just ship the whole thing over and he pleads in front of Judge Hillman. So
that I've never done before. I've never seen it handled that way before. The only thing I can do at that point is then go back and talk to the people who are in mental health court and see what, I just don't work with mental health court very often, so I have no idea.
My question is,
I would prefer to ask.
How would Judge Hillman prefer?
And that's what I have no idea. I would have to be able to go back to my office. At that point, I would not be able to have that answer have that answer plus all of the paperwork ready by the 18th.
Yeah, my preference, I think, would be what would Judge Hillman prefer? A withdrawal of the plea and then take the plea in the sense, or continue with my plea, and then we just transfer the case with the understanding that we shouldn't sentence, because sentencing would be the big roadblock in it.
Correct, Your Honor. And if the court would be willing, to go off the record for about 5 minutes, I could go speak to APA Wilson. She is across the hall, and I could see what that preference would be.
That's fine.
Yep.
And
I think based on my emails with Ms. Besson, and I think that they were okay with the sentencing being done there.
Okay,
But
there,
yeah.
in 55th.
Correct, but I'm not sure if they would want the plea withdrawn here and then taken over there.
Yeah,
So if-
that's my question.
Okay.
They may have a preference, so,
All right, I can get that answer in just briefly.
all right, thanks. All right.
Go for it. Right, and I'm gonna try to get them to dump one dog. See what it plays. So we can go see them, yeah, that'll be.
Okay. All right, Miss Wanji, are you ready to go on, Miss Hats? And you can unmute.
I am, Your Honor.
All right. So this is docket 25-02645. This is People of the State of Michigan versus Emma Hatz. Appearances for the record. Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Ms. Wanji.
Thank you, Your Honor. Melanie Elbiwanch for Ms. Katz, who's appearing from the jail.
All right, and ma'am, you are Emma Louise Hatz, is that correct? And you can hear me all right, Ms. Hatz?
Yes, Your Honor.
All right, thank you. This is time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that at this time we will be leaving the set for the preliminary exam with negotiations to continue.
Is that a fair statement, Ms. Wanji?
It is, Your Honor. Thank you.
All right, we'll set for preliminary examination previously scheduled for September 18th at 9:30. Anything else for the record in 25-02645, Mrs. L?
Not for the People.
Ms. Wanji?
Nothing for the defense, Your Honor.
All right, we'll see you next Thursday at 9:30. Ms. Hatz, thank you for your appearance.
Thank you.
Thank you, Your Honor.
Thank you, Ms. Wanji.
You're welcome.
All right. This Lee's got Duncan and Ray.
Correct, Your Honor.
All right, Mr. Duncan, you can unmute. We'll call your case next. All right, so we're on the record in docket 25-02641. That is People of the State of Michigan versus James Duncan. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of James Duncan.
And sir, you are James Duncan, is that correct?
Yes.
And you can hear me all right, Mr. Duncan?
Yes, I can.
All right, thank you. This is a time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we will be leaving the set for a preliminary exam. Negotiations will continue in the meantime.
All right, and is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
All right. All right, I'm leaving in this, the PCC's held. We're leaving it on for prelim for September 18th at 9 o'clock. That'll be next Thursday at 9 o'clock. So if you have any questions, contact Mr. Lee in the Public Defender's Office. Anything else for the record in 25-02641? That'll be live in person on the 6th floor of City Hall of Lansing. Anything else, Mrs. L?
Not for the People.
Mr. Lee.
Nothing further, Your Honor.
All right, Mr. Duncan, we'll see you live in person September 18th at 9 o'clock. Thank you for your appearance today.
Thank you.
Then we can go on Mr. Ray. All right, so we're on the record in docket 25-02648. And Mr. Ray, you can unmute. Thank you. We're on the record in docket 25-02648. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Caleb Ray.
And sir, you are Caleb Ray, is that correct?
Yes, sir.
Thank you. And you can hear me all right, Mr. Ray?
Yes, sir.
Thank you. This is the time set for a probable cause conference. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we are going to be leaving the set for the preliminary exam.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
Right, probable conference, PCC conference was held, and we'll leave on for September 18th at 9:30. That'll be next Thursday at 9:30. That'll be live on the 6th floor of City Hall of Lansing. Anything else for the record in 25-02648, Mrs. L?
Not for the People.
Mr. Lee.
Nothing further. Thank you.
All right, Mr. Ray, we'll see you in person next Thursday at 9:30. At 9:30. Then, Mr. Net, did you need to speak with Mr. Carter for a second?
About 15 seconds.
All right.
We're ready.
All right.
You're not. I didn't see the confirmation. Address of the violation. Just revoking passes. Get acceptance.
All right, so we're on the record in docket 24-02551. That is People of the State of Michigan versus Cameron Carter. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Ned.
Thank you, Your Honor. George Annette, APD on behalf of my client, staying to my right.
And sir, you are Cameron Carter, is that correct?
Yes, sir.
Thank you. This is time set for a probation violation hearing. And Mrs. L, how are we proceeding?
Your Honor, if I could defer to Mr. Renner.
Mr. Ned.
Thank you, Your Honor. It's my understanding that probation is a privilege. My client is indicating if we can withdraw
that privilege is to be sentenced without addressing the violations. If the court wants to address the violations, I'll say what I have to next.
All right. I have the violations are concerning, are they July 15th, those violations?
Yes.
And so the recommendation would be as specified. I've already done the judgment of sentence. So if Mr. Carter were to admit to a violation, I could just sentence him on the violation, if that's the ultimate goal here, if that's what you're seeking.
Yes, all right. Bear with me 1 minute.
And then I'd let you pick the violation.
Okay, that's what, okay. I saw another page of the violation, trying to see if I could find it here. It was one was for absconding, the other one was for
correct.
Oh, can we do violation 16, fail to enroll in complete anger management as directed?
Yes.
That prevents any.
Yeah, that would be a technical probation violation.
Okay, we'll plead on that. Admit responsibility on that.
All right. All right. So in regards to, so Mr. Carter, you understand you have a right to a hearing today. You've seen the recommendation that's been presented you've seen the recommendation. It is my understanding, it is your wish today to plead to a technical probation violation and then go to the sentencing concerning this matter. That'd be violation 16, fail to enroll in or complete anger management program as directed. Is that your understanding? That would be your wish today to plead to that violation?
Yes, sir.
All right.
First.
All right, I'm gonna have to raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury, Mr. Carter?
I do.
All right. The allegation that was brought by probation officer Sumter is that you failed to enroll in or complete anger management program as directed. How do you plead to that technical probation violation?
Guilty.
All right. With that understanding, the non-technical probation violations will be dismissed or set aside since we have the violation of number 16 and then allocution of Mr. Annette.
Thank you, Your Honor. Mr. Carter is currently serving a sentence in Wayne County that is for the dismissed allegation in Dearborn Heights for fleeing and looting. Outdate is December 1st. It wouldn't make any sense to postpone probation for any sort of, once Mr. Carter's done, he wants to be done. It's an unfortunate set of circumstances that he wishes would have never happened. Fortunately, these are the circumstances we're stuck with. I'd ask you assess fines and costs, Your Honor, and no further jail, as Mr. Carter is going to be in jail for another 3 or so months. Nothing further, Your Honor.
All right, thank you. Mrs. Zell, anything towards allocation? It appears that Mr. Carter is December 1st is the outdate you indicated?
Yes, sir.
All right.
We would leave this to your discretion, Judge.
All right. Mr. Carter, is there anything you'd like to say to the court before the court passes sentence?
I apologize for the violations. And I accept the thing. I apologize.
Okay. All right. So the sentence to the court, I have the pre-sentence recommendation. There's a lot of things on Mr. Carter's plate. So this is just one of those. I'm going to terminate probation. I will sentence Mr. Carter to 60 days. And he can do that while he's waiting on the for the in concert. I think he's getting credit because we set it at $1,000, 10%. So 60 days on the current offense. That's file 24-02551. And that's the plan. The plan is to have the 60 days sent concurrently with the Wayne County sentence. So the 1,010%. So I wouldn't make bail on this case because you're getting credit for that. Fines and costs will be waived. And the state fee, I can barely write on this, because I'm running out of room. The state fee and the crime victims' rights fee are waived. Is there any restitution on this matter, Mrs. L?
I do not believe there is,
All right.
Your Honor, but if I could double check.
I didn't see a pink
There
sheet.
is. It's $355. But I don't know to whom.
I have no pink sheet in this. But there'll be that rest because of the jail sentence, we won't worry about restitution. So restitution is not ordered because of jail sentence. All right, anything else for the record in 2402-551, Mrs. L?
Not for the people.
Mr. Ned.
Thank you.
All right, Mr. Carter, you should be all set. Thank you for your appearance. You're all set.
What about HYTA? Are you revoking it?
Yeah, well,
Leaving?
yeah, revoking.
Okay.
See you next
Just the
week.
jail sentence. So I'm following the recommendation and just ending probation and sending 60 days to the jail, to the Ingham County Jail.
Okay.
I think that's the docket this morning.
It sure is. It sure
There's a
is.
lot going on.
Have a good day, everybody.
You too, Mr. Ned, Mr. Etheridge.
Your Honor, I do have both of our interns from the office in here if you'd like to meet.
I
them.
would. What's your name, ma'am?
Hannah Buckingham, and actually I once, so you worked at Cooley adjunct,
I-
and I have to say a delayed thank you because you gave me access to your evidence canvas.
Did I really?
You did, and so a delayed thank you for helping me with, or actually Crim Pro, I think it was.
I taught evidence and Crim Pro there
Yeah.
over the last years. I used to be on the faculty there.
Yes,
Yep,
yep, I did
so-
know that. Yeah, I TA'd with Lewis, and now I'm TAing with Martha. So,
All right.
Yeah.
All right.
It's
So you
nice
have
to-
Professor Moore.
Yes, I did. Yep. But
All right. Well, it's nice to meet you, Buckingham, correct?
Buckingham, yeah,
All
and
right.
it's great to see you in your element.
Yeah, it's not new anymore. It was
Yeah.
once new.
anymore. You were a California guy, right?
I'm an Arizona guy.
Oh,
Yeah,
Arizona.
I grew up out west.
Gotcha. Okay.
So it was kind of funny because we had a Flores today, and I can guarantee you, All right, Ms. Newbecker and Ms. Ellison, I think we're still waiting to see if your responding parties show up. We've got, so somebody just joined the Zoom room. We're going to start on another case and then we'll call your cases by two. All right?
Okay, thank you. Thank you.
Thank you. All right, and then Ms. Delgado and
How come I can't?
Jones Family Construction, you can come up here. And you can go ahead and have a seat. All right, so we're on the record in 25-02687. Appearances for the record, ma'am, you are Monica Delgado, is that correct?
That is correct.
All right. And sir, you're a representative of Jones Family Construction?
Yes, sir.
Thank you. What's that?
Can I have his first name?
What's your name, sir?
Lloyd.
Lloyd, and your last name?
Floyd.
Floyd?
Yes.
Spell it for me, please.
Floyd.
And your last name?
Jones.
And spell that for me.
Jones.
All right, thank you. Now let's see if we can flip on base. This time set for a hearing today. This was from magistrate disqualification. So it's now, we're now in court. And so I'm going to have you sign the appeal waiver. This is usually, I get the magistrate's decision once that it is, a decision's been made, and then I review it de novo, which means that I review it from the very beginning.
Okay.
So this doesn't happen, that's not how this is happening. The magistrate's disqualified herself. I've stepped up, said that I will take the case, but you're going to have to sign the documentation indicating your rights on each. So if you read that through, if you disagree with it, then it goes to another magistrate. If you agree with it, it comes to me. You can look at it, review it, and then if you agree with it, sign the bottom. If not, then we'll go from there.
This is just like, like for what claim or whatever the jury trial stuff, that's like to skip all that.
Yeah, there's no jury trial here.
Oh,
okay. This is all small claims. You're not represented by counsel. Usually a magistrate would hear a small claims problem. The magistrates recuse themselves. I've stepped in, and so there's no appeal from my decision.
Okay.
That's usually, and if you want a jury trial, you'd have to get a lawyer, make the payment. You have to pay for.
I don't mean for all the questions. This is my first time.
All right. Yeah. No, I understand completely. So that's just telling you there's no appeal from the decision. And usually it comes, I get these cases when they appeal the magistrate's decision.
Okay.
And this one, she disqualified herself, and then I stepped in. That's the only difference in the category, how this got in district court.
Okay. Gotcha.
And then my court officer will take it to Ms. Delgado. All right. And it's for these reasons. Okay, so we'll sign and scan it into our e-file system because all this is done electronically now. We'll sign and scan it and provide copies to both of you for your litigation purposes. All right, and so I'm assuming today so this takes a little different route, and so it's now in district court, okay? And there's been no appeal from district court. I'm assuming what you'd usually have is a small claims hearing, in which you'd be able to bring any evidence that you have, and then I would make a decision on the merits of the case. I don't know if you're prepared to do that today. Okay. I don't know if you've had that's what normally would happen. You take the stand, you testify. We don't have any lawyers here, so I'd probably have you testify, and then you do any cross-examination questions through me. But I don't know that you have all the documentation or exhibits that you had planned to have. I saw that Ms. Delgado has a complaint essentially indicating a chronology of the events. That was entered in. So what I would do is set this for hearing date and allow you to bring in any evidence you want the court to consider. And that would be any receipts, anything that you've gotten receipt-wise that you could testify to and say, look, I brought a receipt, and then show it to me. We'd mark it, we'd admit it in evidence. Make sure Mr. Jones gets to see, is it Mr. Jones?
Yes, sir.
Mr. Jones gets to see any of the exhibits, and then you do the same for Ms. Delgado, and then I'd make a decision on the merits of the case, depending on. This was brought by Ms. Delgado. So she has a burden of proof. So that's usually how I would do things. I know that when we get appeals from small claims, the parties aren't always ready to go to hearing that date because they didn't bring everything with them.
Right.
And so what we've done in the past is we've adjourned the hearing, allow the parties to bring in everything to be marked, and then we have the hearing on that date, some date in the future. Mr. Jones.
Your Honor, is there a way, because I have no proof of none of the exhibit stuff, I'd like to be able to go over the things and be able to.
You should be provided before, since this is a hearing,
okay.
You should be able to go through any of the exhibits beforehand,
yeah.
Before Ms. Delgado moves for the admission.
Yeah, I have had no chance to go through anything.
Because she would indicate,
right.
I'm testifying to this, here's the receipt, right. I've gotten this from, whatever plumber or, yeah. And then I'd give it, those should all go to you, copies should be made and given to you so you understand the nature
correct.
of the receipts.
Correct.
It's that usually is not done in small claims initially, but I like to see that every testimony has I want to see all the documentation, I want to see all the exhibits. And usually we don't bring them for the first hearing.
Right.
So that would give me the chance to look at them, have you look at them, have you look at them, and any of Mr. Jones's. And then we can see if we're on the same page. If there's a disagreement, I'll make a decision on the disagreement. Okay. So you say like, I don't like that estimate, then I would say, well, that's the estimate and you can voice your concerns with it. Okay. So generally that's what I do, okay? Generally I adjourn it for a month, let you get all your stuff together, and then you can come in and we can have what essentially is a small claims case in district court. Usually the parties are not ready to go to hearing because they only bring testimony. And you may have your testimony, which is evidence, but you also have receipts and other things that you want the court to consider. I think I should be privy to all that. Is there any comment on it would be the court's practice to probably adjourn this 2 to 3 weeks, since this is our first hearing, treat this more like a pretrial, and then come back with all the indication, and we're ready to go to hearing on that. Ms. Delgado, do you have anything for any statement for the court?
I have all my documents and I had prepared a packet for you to look at.
Okay, and I have not looked at anything.
Correct.
So make copies of those documents, provide them to Mr. Jones, that's what you're using, and then you can provide that to me to look beforehand. All right, because I need some time to look at all your documents. How many documents do you have now?
I do have a stack.
What's that?
I do have a stack of photos and estimates.
So you want each one of those marked as evidence for Mr. Jones to look at and for myself to look at and for the court to record as an exhibit as part of the hearing. I would assume that's what you would want.
I had labeled all the exhibits.
All right. Yeah, your labeling is wonderful, but it doesn't mean anything. Only the court's exhibits mean something. And so let's do, so you're kind of done, okay? What you need to do is make a copy for Mr. Jones so he gets to see all the exhibits that you plan on moving so I can see them. And then you should let my court officer, well, how many exhibits do you have? How many labels did you mark? Because I think we probably
A through L.
A through L. So A, B, C, D, E, F, G, H, I, J, K, L. I would say, what, 22?
I mean, and of course, the payments and receipts that
So that's gonna be all part of your testimony. So A through A, B, C, D, E, F, G, H, I, J, K, L, that's 12. So I would say in the realm of 14 exhibits. We put 12 plus 2 just because there might be extras. So that's what Ms. Holden would have to mark in order for the court to see. So that's what we'll expect you to bring at the next hearing, okay? And you should make a copy of all that for Mr. Jones, right? Because Mr. Jones should have, because he
That
should
way I
have.
have something to question too of the
Correct.
situation.
Well, and you can prepare a cross-examination. You'll have questions from Ms. Delgado, because I'm assuming it'll be part of your testimony. And then you'll testify, but any questions will be through me.
Yes, sir.
All right, just to make sure that we run it efficiently, and then that we're being respectful to one another.
need those ahead of time or the day of court.
I probably need, we'll mark them probably the day of court. Okay. Mr. Jones will need them ahead of time.
Okay, how do I do that?
Probably just copy them and then provide them to Mr. Jones at whatever.
She's got the address. She can mail them to me.
Or email them, or can you email them?
Um,
That might be easier, so you don't have to spend the copying costs.
I don't know.
I'll provide that.
No, well, we're gonna put it on the record. This is all on the record. So, would you prefer to email them or provide a copy to an address?
Either is fine.
All right.
Hard copy would be great.
A hard copy would be great, but it's more expensive for you. So I'm gonna have her email them provide the email address that she can send any prospective exhibits.
Okay.
What would be that?
It's Jones Family Construction
Jones Family Construction
2020
at
@gmail.com.
So Ms. Delgado, you have that address.
It's on his estimate.
All right. And then any exhibits that you have, Ms. Delgado should have before the hearing.
Yes, sir.
So any receipts or anything you put together, and what is a good email address so you don't have spending money on copy?
Yeah, everything's electronically through where we got the materials from, because everything was ordered.
Yeah, but I don't know what everything is.
Right.
So you should provide anything you plan to use as an exhibit.
Yes, sir.
And if you're motioning for an exhibit, you should provide to Ms. Delgado.
Sir.
What would be a good email address for you?
It would be Monica
I think I do have it at home.
All right, let's get it for the record. So it's Monica
at my first and last name, Monica Delgado.
Monica Delgado.
Speaks, SPEAKS.com.
SPEAKS.com.
Correct.
All right, and you could send anything any evidence you want the court to consider that you're going to move for admission. You can send to that. You sent that address.
Yes, sir.
That way, I know that both parties have seen all the exhibits.
Yeah.
And then beforehand. All right, let's get a date. What's that?
How much time do you want with this?
I'm thinking about 2 to 3 hours of testimony.
Okay.
At least for your testimony and your testimony. That'd be an hour each. And then do you plan on calling any other witnesses, Ms. Delgado? All right, Mr. Jones, do you plan on calling any witnesses at this
I
time?
have some, Your Honor, but I'll have to work on that a little bit.
We'll do better. It's been my experience over the years. We probably do better safe than sorry. So maybe we'll provide like an afternoon.
Okay.
Okay. But I'm going to indicate that the parties signed the waiver.
If I have any issues with work, because I am a union worker, is there anything that I can just get a hold of you, let you know about the timing or how that?
Well, I'm going to give you a date and time now that hopefully
Cool. So
that
that way
you
I can work it in.
you can work it in.
Okay, cool.
I would suspect it'd be about 30 days out.
Okay.
Parties signed the waiver and we'll set for formal hearing, which is really, a formal hearing is just a nice way of saying a bench trial in front of myself. So bring in any documents want the court to consider, give it to each other. That'll be live in person. Zoom will not be appropriate. It's really hard to do an adversarial hearing via Zoom. And so let's start with this date to see if it works.
November 6th at 1:30.
November 6th at 1:30.
That'll work for me.
Will that work for you, Ms. Delgado? I think that is a Thursday afternoon.
My busiest season is October 15th through December 7th. Because I'm a Medicare insurance agent, that's annual enrollment period. It's our busiest time. That's why I was hoping to present today, and
Yeah, and
I understand.
yeah, what, because I can try to present today, but you'd be catching, I wouldn't have the opportunity to see all the exhibits, except for maybe adjourn to a date where but Mr. Jones, I'd adjourn to let Mr. Jones come in with any documentation. So that might speed up the process if I see some of it today, but Mr. Jones has none of the exhibits or seen none of the exhibits.
Is there any possibility of after December 7th?
There's a tremendous possibility of after December 7th, if you want us to push it that far. We were trying to make it sooner than that, but if you're okay with the longer wait, that would give Mr. Jones the opportunity to put it in a schedule. Yeah, we can make it after December 7th. I don't think we've scheduled that far yet, but that'll work. But I know that
Medicare, for people on Medicare,
yes,
that's a really important time.
I know that'll work, and we'll give you a time and date.
Okay, cool.
So bench trial after December 7th.
Working on it. Okay. Sorry.
No, this actually works this works for us, not against us.
Okay.
It's trying to schedule it earlier where it presents the problems.
December 9th at 1:30.
December 9th at 1:30? Sure. Okay.
Sorry, 2:30.
2:30. All right, we will set this for December 9th at 2:30. You can provide any documentation, make sure the other side has it. And then if you want me to look at it early, you plan on motioning for it, you can provide that to the court. But I probably won't look at it completely till you motion it in, because that's the time that I'm actually going to see the marked exhibit and read it out loud, and I'll have the context of testimony at the same time. That's the easiest way to proceed, to say like, okay, this happened and here's to confirm this happened and here's to confirm that. Any receipts or anything you want the court to consider. All right. All right. So we will set it for December 9th at 2:30. Do you have any questions of me, Ms. Delgado? Mr. Jones, do you have any questions?
No, sir.
You should be all set. Thank you for your
All right, thank
courtesy.
you.
Have a nice day.
You too. Then, ma'am, do you have a hearing today?
It's supposed to be a two bill for 2 o'clock. Just show up.
All right. We have some 130s. These are the 130s we're just going through. So we're going to call your case in just a second. So who's covering? Miss Newbecker, you're covering for Mr. Smith?
Yes, I'm covering for Timothy Smith for LAFCU, yep.
All right, and that is 01. And do you know if Dustin Moore is here, or representative of Dustin Moore? I don't see Dustin Moore, but I see several attorneys. Is anybody here in representation of Dustin Moore? All right. I think we have the answer, Ms. Newbecker.
Okay. So
All
we'd
right.
like to, I'm sorry.
All right, so let me call the case and then we'll proceed. We're on the record in docket 0101793. That is LAFCU versus Dustin Moore, Appearances for the record, Ms. Newbecker.
Janelle Newbecker for Lafque plaintiff.
All right. And I have the attorney's record as Timothy Smith. Are you covering for Mr. Smith? Are you here for Lafque?
Yes, I'm covering for Timothy Smith. I work at Smith and Johnson with Timothy, and my P number is P98 or 79874.
All right, thank you. This is the time set for a show cause concerning and I'll indicate that for the record. We previously were here on July 28th. We scheduled a show cause hearing. Notice was sent with a 9-day notice. This was scheduled for 1:30. It is now 2:08. I do not see Dustin Moore in the Zoom courtroom. Nobody answers by that name, Mr. Moore's name in the physical courtroom. And Mr. Moore was not in the hallway last we checked. It would appear that the D1 has failed to appear for the show cause hearing. And Ms. Newbecker, how would you like to proceed?
We'd like to ask that the court issue a bench warrant for his arrest for failure to appear, and then to show cause why he shouldn't be held in contempt.
All right, and I think for the second failure to appear, we'll issue a bench warrant. What is the collection price? The total collection price?
The total as of today is $1,325.35.
All right, I'll issue a bench warrant verbally for $500 cash or surety.
Okay.
And then you'll submit the order to that effect.
Yes.
Is that
Yes,
correct,
thank you.
Ms. Newbeck?
Yes.
All right. All right. For the fail to appear for the show cause hearing, a bench warrant will be issued for the amount of 500 cash surety. Order to follow. Anything else for the record in docket 0101793, Ms. Newbecker?
No, thank you, Your Honor.
All right, ma'am, you're all set. Thank you for your appearance today. And then we have the second Lafque case. So give me 1 minute. Give me about 30 seconds to make some notes, and then we'll go from there. All right, Ms. Newbecker, are you here on the second Lafque case on Philip Maston Bean?
Yes, I am, Your Honor.
All right. All right, so we're on the record in docket 1602314. That is Lafque versus Philip Maston Bean. Appearances for the record, Ms. Newbecker.
Janelle Newbecker for plaintiff Lafque, and I'm appearing on behalf. I guess not really on behalf, but I'm substituting in for the attorney of record Timothy Smith, and my P number is P79874.
Thank you. And I do not see a Philip Maston Bean in the Zoom courtroom. There's nobody by that name in the physical courtroom, and there's nobody by that name in the hallway. Is there a representative of Philip Maston Bean? Ms. Howard just joined us. All right, this was set for 1:30. It is now 2:12. it would appear that the defendant has failed to respond, has failed to appear for the show cause hearing. This was previously set on June 10th, 2025, in which the Mr. Massenbean was not able to appear. We've set it for show cause with a 9-day notice. Ms. Newbecker, how would you like to proceed?
We'd like to ask that the court issue a bench warrant for Mr. Massenbean's arrest.
Failed to appear for show cause. And what is the underlying amount that Mr. Massenbean owes?
The current amount that he owes as of today is $14,434.01.
Right, I'll issue a show cause for $400 show cause. The warrant will be issued, and you'll follow that up with an order, Ms. Newbecker.
Yes, and I just wanted to clarify the bench warrant will be issued with the $400 for bond.
Correct.
Okay,
Correct.
thank you. Thank you.
All right, so follow up with the order on the $400 for the bond recommendation for the bench warrant for fail to appear. Anything else for the record in 1602314, Ms. Newbecker?
No, Your Honor, thank you.
All right, you should be all set, ma'am. Thank you for your appearance today.
Oh, I think I actually have one more. It's the Lafkew versus Morgan, Demaria.
Correct.
Okay.
All right. So we're going to call a couple cases in front of that, and then we'll go on that case.
Okay.
All right. And then we have, is there a representative from the Cox, Miss Ellison? You're from the Cox Law Firm. Marvin Dunham. And I don't see 121. All right, so we're on the record in docket 21-02877. That is Oliphant Financial versus Marvin Dunham. Appearances for the record, Miss Ellison.
Good afternoon, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
This is the time set for a discovery hearing. I do not see a Marvin Dunham in the Zoom courtroom. There's nobody by that name in the physical courtroom or the hallway. This was scheduled for 1:30. It is now 2:15. It would appear that Mr. Dunham has failed to appear for the discovery hearing. Miss Ellison, how did you want to proceed?
Your Honor, he was personally served at his new address in Southfield. I didn't know if it was this court's preference to do a show cause before request.
I think the policy is to do a show cause first. And so we'll set this for a show cause hearing, just in case Mr. Dunham can appear. We'll do it, set it for show cause hearing. And civil usually sets that, right? So the civil department will set the show cause hearing. I think I can sign the show cause hearing. I usually do a 9-day notice. I think that's required by the court rule. 9 days prior, that they be served 9 days before. But we will set it for show cause hearing and have the civil department set it for the fail to appear.
Okay, do you want us to submit the motion affidavit in order to show cause and then?
Yes, we do.
Okay, perfect. I'll have my office submit that. Thank you so much.
All right, thank you. Anything else for the record in 21-02877, Ms. Ellison?
Nothing, Your Honor. Thank you.
All right, you should be all set. Thank you for your appearance today.
Thank you.
All right, Ms. Newbecker, we can call your next case for Lafque and Demaria Morgan.
Okay.
All right, so we're on the record in docket 1700467. That is Lafque versus Demaria Morgan. Appearances for the record, Ms. Newbecker.
Janelle Newbecker for plaintiff Lafque, substituting in for Timothy Smith, attorney of record. MIP number is P79874.
Thank you. And ma'am, you are Demaria Morgan, is that correct?
Yes.
All right. This is time set for a show cause hearing on a motion to show cause. And this came out of, did this come out of a discovery hearing, Mr. Becker?
It did, yeah. We had the discovery or debtor exam hearing was scheduled for June 30th. And she failed to appear for that hearing, and then we have the show cause hearing. Obviously, is today.
All right. So, Ms. Newbecker, I twofold. I'll leave it up to you. I can swear Ms. Morgan in and have you start the discovery hearing, or we can set it for discovery hearing. It's really up to you.
I wouldn't mind just getting started on it today, just to see what information she can provide.
All right. So, Ms. Morgan. We're going to start the discovery hearing. We won't be issuing any bench warrant for non-appearance, which is a good thing here. Okay. And so let me swear you in, and then I'm going to put you in a breakout room with Ms. Newbecker for some privacy, and then you can go through, and then we'll come back and place it on the record. All right, ma'am?
Okay, thank you.
All right, Miss Morgan, I'm going to have you raise your right hand as best you can. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, Ms. Newbecker, I'm going to have you placed in room 1. You should get a prompt to go to room 1. And with Ms. Morgan, you'll also get a prompt to go to room 1. And then they're probably going to come back and put it on the record, I hope. All right, so let's put that aside. And $25,03713. All right, so Mr. Begg, you're here for LVNV funding?
I am. I've got that at 2 o'clock, and then I've got Midland versus Whitby at 2:30.
All right, perfect. All right, so we are on the record, and I don't see a Michelle Bill.
So she's in the courtroom.
Oh, Miss Bell, I forgot about you. You can come in here. We're so used to doing things on Zoom. All right, so we're on the record in docket 25-03713. That's LVNV Funding LLC versus Michelle Bell. Mr. Begg, your appearance for the record.
Attorney Jay Begg, BAIG P36820 on behalf of plaintiff.
And ma'am, you are Michelle Bell, is that correct? All right, thank you. This is the time set for a pretrial in the matter. And so you have several options on how you want to do a pretrial order. Ms. Bell is really just setting up a time frame. We set up the time frame. We see what motions are available. It's all. But before we do the pretrial, Mr. Begg, did you want the opportunity to speak with Ms. Bell? I can put her on an iPad and put her in a room if she's amenable, and you can speak with her, and then we can come back. I can do the pretrial, or Mr. Begg can do a pretrial and let you see it. There's various ways to do that. But if he's amenable, Mr. Begg may want to talk to you, may not want to talk beforehand. It's entirely up to you, but I provide the parties a chance to speak to one another, okay? Mr. Begg, would you be amenable to, did you want to speak with Mr. Begg?
I wanted to know that. I don't know what he wants, because like I said, I don't.
I'm sure he's gonna tell you.
All right, he can talk to me.
Mr. Begg, would you be amenable to speaking with Ms. Bell in a breakout room?
Sure, I don't mind doing that if she's if she wants to discuss settling it, yes. If she needs more information about what this is all about, then maybe a scheduling order with discovery might be more appropriate.
All right, so do you want to do the discovery? The part of the pretrial order is a discovery, and that's when you'll be exchanging information. If you want to talk about settling, Mr. Begg, we'll talk.
I don't
to you.
have anything to do.
All right.
I don't have a bill with him, so.
All right, so
Same.
let's print out a pretrial order, and I can fill it on the record.
All right,
All
thank
right, you're welcome. So, Mr. Begg, we'll fill out a pretrial statement order, and we'll fill it out on the record. One
very
thing,
good.
is this a debtor collect? Is this a debtor collection? So is this a credit card, Mr. Begg?
Yes, it's an account. It's a the original creditor is Finger Hut.
We'll just stick that in. All right, give me about a minute, and we'll print out the form. All right, so we're on the record in docket 2503-713. The pretrial form has been printed out. This pretrial conference is held on September 11, 2025. Appearing for plaintiff was attorney Jay Bagg. Defendant is in pro per. Ms. Bell is in per per. We are determining this legal issues and a breach of contract. The pleadings that do you expect any more pleadings in this matter, Mr. Begg, other than a motion for summary disposition?
No, just a motion for summary.
All right, and then Ms. Bell, do you expect any more pleadings other than the answer? We're holding back on a motion for summary disposition since we haven't had discovery yet.
Correct.
All right. Motions, we hold on to the motion for summary disposition and response. And that should be filed by the end of discovery or at the end of discovery, indicating no on consolidation of cases unless I hear differently from the parties. The admission of fact or exhibits are not applicable. Discovery is set, the cutoff date for discovery is set for December 10th, 2025, all right? And you'll get a copy of this. So December 10th, 2025, expert witnesses damages have been pled for, and there is a joinder of claims. Both those are seen as non-applicable since we haven't had the full discovery notice. Has either side paid for a jury trial at this time, Mr. Begg?
No.
Miss Bell, have you paid for a jury trial? All right. So we've estimated half day or a day for bench trial, something we'll look into. Negotiations are ongoing in regards to settlement. Is there any reason that this case should be referred for evaluation or mediation, Mr. Begg?
No.
All right. Ms. Bell, you're not seeking any type of mediation in this case.
I don't understand.
Mediation is really both parties have to be involved, and they kind of a mediator who's trained by the Alternative Dispute Resolution Center sits down and sees if we can work it out. I don't think we know enough right now to have it. That's always an option, but right now I'm going to put no for mediation. And usually it requires both parties to be involved, and really we don't know enough about the case. All right. Mr. Begg, do I have your permission? All we've done here is set a discovery for December 10th. We have a bench trial, and we've held back on the summary motion for summary disposition and response. May I sign this via Zoom on your behalf?
Yes, Your Honor, you can send my name.
And Ms. Bell, I'm going to provide this to you. And I've signed via Zoom by Mr. Begg's name. You can take a look at that and then if you want to, you can sign that. All right. I'm going to sign as sitting judge on today's date. So the pretrial is complete, but the cutoff time for discovery will be December 10th, 2025. And then you can contact Mr. Begg or the law firm to see if any discovery materials, that's the time we'll set for interrogatories or depositions or anything of that matter, or any paperwork they might need, all right? And then you can do the same, all right? I will provide the pretrial statement, a copy for yourself since you're here, and then we'll send one out to your law firm, Mr. Begg. Anything else for the record in 2503713, Mr. Begg?
No, Your Honor, thank you.
All right, any questions of me, Ms. Bell?
No. So
All right.
I will have to be back here, December 10th?
December 10th is the cutoff date. You'll get a notice for when to come back if you need to come back, all right? But that December 10th isn't the date you have to come to court.
Okay.
Okay, all right. That's all for the record in that file. Thank you, everybody, for your appearance.
Thank you.
Thank you, Mr. Begg.
I'll wait for the other one whenever you're.
Okay, perfect.
Thank you. Thank you.
Let's identify some of these people. On the iPhone, could you please identify yourself? Ma'am, on the iPhone? What's your name, ma'am?
Brooke
Yeah, I don't
Ridge.
know if you're hooked up. Ma'am, I don't know if you, I don't.
Speak up.
Let's see,
Oh,
participants.
there we
I
go.
don't know if you're participants. I have you muted. Can you unmute on the iPhone?
Yes.
Ms. Ridge, I have you. I can hear you. You're all set.
Okay.
This is under the person or moniker of iPhone. Ma'am, what's your name?
Brooke Ridge.
Yeah, Ms. Ridge, you're all set, Ms. Ridge.
Okay. Thank you.
So you can unmute on the iPhone. You can unmute.
Yes.
And please identify yourself.
Brooke Ridge.
Ms. Ridge, you're perfect. Okay, I'm trying to identify the person that next to you on the iPhone. Could you please identify yourself so we can relabel you as something other than the iPhone?
I'm not you. Oh, not me.
And for whatever reason, your microphone's not working on the iPhone because I can't hear you.
He's talking to you. No, he's not.
No, I'm not talking, Miss Ridge. I'm not talking to you.
I know.
By the way, we can hear everything you're saying, so you might want to mute yourself. Ma'am, you're on the iPhone. I still can't hear anything you're saying.
Can you hear me now, Judge?
I can. Ma'am, what's your name?
It's Ivory Whitby.
Ivory Whitby. All right.
Yes.
So let us rename you Ivory Whitby, and you're here for your 2:30. Is that correct?
Yes, I am.
All right. All right. And
That's
Mr.
mine.
Who is here for JP Morgan?
I'm here on that one, Your Honor, Frank Price.
All right, perfect. All right. I think we have Zoom conquered and for this minute. All right, so we're on the record at 25-04295. That is JP Morgan Chase Bank versus Brook Ridge. Appearances for the record, Mr. Price.
Frank Price, P82598 on behalf of plaintiff JP Morgan Chase.
And ma'am, you are Brook Ridge and you can unmute.
Okay, yes, I am Brook Ridge.
All right, thank you. And you can hear me all right, Miss Ridge?
Yes.
All right. This is the time set for a pretrial in the matter. And so I always give the opportunity for the parties to meet if they have not met, and then we can come back off the record and I can fill out a pretrial form. Mr. Price, you could fill out you could do your own pretrial form and let Miss Ridge. All the pretrial form is scheduling a calendaring events. So it's a scheduling order is what it is. We also keep motions for summary disposition. We hold those back because those might come after discovery. Mr. Price, do you have a preference as you'd like to proceed? Would you like the opportunity to speak with Ms. Ridge?
Yeah,
or do you
I
want
think
us just to fill out the pretrial?
before we do any kind of scheduling order, if Ms. Ridge is interested, we could go in a breakout room and have a quick discussion.
All right, Ms. Ridge, would you be amenable to the court placing you in a breakout room to speak with Mr. Price, and then we can put it on the record?
Yes.
All right, I'm going to indicate that all parties appeared and to meet in a breakout room. We'll add that note and all right, so Mr. Price, I'm going to move you to room 2, and then we'll move Miss Bridge to room 2, and then we can come back and put it on the record. All right, so Mr. Begg, we're ready to call the Midland case, and that's with Miss Whitby. All right, so we're on the record in docket 230224. That is Midland Credit Management versus Ivory Whitby. Appearances for the record, Mr. Begg.
Good afternoon, Your Honor. J. Begg, BAIG, P36820 on behalf of plaintiff.
All right, and ma'am, you are Ivory Whitby, is that correct?
Yes, I am.
All right, this is the time set for a motion in the matter. I'm going to read your motion into the record, and then I'll have a response by Mr. Begg concerning, because there was a response filed in regards to the objection to periodic garnishments. The motion reads, on August 28, 2025, I picked up a letter from the post office. The garnishment was not served properly. I never received any court documents regarding neither case. I'm asking the court to quash the writ of garnishment due to financial hardship since COVID. I asked the court to dismiss or lower the judgment. That's the sum and substance of the motion. I did check to see, and Ms. Whitby was provided service, and it was signed previously. Where's my sticker? There it is, the blue note. On September 29, 2023, not for this date, but for the previous default that was indicated. And then I have here a description of the person, and that Ms. Whitby was personally served, but refused to sign on the document. Mr. Begg, in regards to this motion, which is what the only reason we're here for is a motion to quash the writ of garnishment. I have had the opportunity to read your objection to the periodic garnishment? Is there anything you'd want to supplement in way of argument concerning that objection?
Just simply, she hasn't articulated a specific reason that's required by the court rules. First of all, she states the garnishment was not served properly. Well, the plaintiff's counsel doesn't serve, isn't required to serve the garnishment. The garnishee defendant notifies her, which she did find out about the garnishment in that fashion, and then the rest of it is where she's challenging the judgment, which is not a proper objection. So I would request that her motion be denied.
I would like to object to that.
Ms. Whitby, is there anything you'd like to say in regards to your motion?
Yes, sir, Judge. I would like to object to that. I did not receive any paperwork in regard to this. The attorney and the individuals they are working for are lying. I was never present and refused to sign anything. I have not received anything. I have not stayed at this address since 2022, sir, and I can prove that. I have not lived at this address. My license can show you my new address, and since then I have another address. So I've lived at 3 different addresses since 22. They are lying, Your Honor. They have not served me nothing. The only thing I've got in regard to both of these cases is what I received on the 28th at my job. They skipped over all of this and came straight to my job and brought this straight to my job for garnishment. They did not ask me to sit down to ask me if I wanted to pay it off. They did not come to me and ask me if I wanted to pay off or do a payoff or anything. They are lying, Your Honor. I have not received anything, and I can prove to you I have not stayed at that house since then. And I can prove to you my new address. I did not get anything from these people at all, period. No paperwork, nothing asking me to pay it off, nothing. The only thing I've got is this garnishment to my job.
But first of all, we can't litigate the underlying offense. This is a collections issue. Second, I have you served on September 29th, 2023. Have you personally served, ma'am? So, Ms. Whitby, I have you personally served on September 29th, 2023. This went to default because you failed to answer the complaint.
I didn't receive anything, sir. I haven't received anything.
All right, the objection is denied. I'm sorry, the objection is granted, the motion is denied. The motion is denied. And Mr. Begg, you'll follow up with an order to that effect. The objection is granted.
Hold on. I think Your Honor, the language objection.
So you filed the objection to the. I have plaintiff's response. Oh, your response is granted. I get it. Right. You filed a response. All right.
Correct. So that's
so the response.
Yeah, you don't want to say the objection is granted because her motion.
So what is this? The judge and this lawyer, you guys are teaming up against me? Because I'm telling you, Judge, I did not receive anything.
Miss Whitby, a hardship is not due financial hardship, and COVID is not an adequate objection. All right, that's not an adequate objection under the court rules. So I am granting the objection to the periodic garnishment. I am denying the motion for to quash a writ of garnishment. And I'm just reading that because that's the way it's said. So I'm denying your motion and I'm granting the response. And Mr. Begg, I think that should suffice for following up with an order to that effect.
Right. Except I know what you're saying, Your Honor, but you don't want to say objection because her motion.
How are you going to tell the judge what to say? What are you guys teaming up against me?
Can you
Miss Whit,
please let me
Miss
speak?
Whitby, Miss Whit,
Please let me
Miss
speak.
Whitby, Miss Whitby,
Trying to make
Mr. Beggs just clarifying what I'm gonna sign the order to.
So so the judge, the lawyer is telling you as the judge how to proceed in this case.
Ma'am, I'm gonna mute you. Go ahead, Mr. Begg.
Okay, you probably don't want to use the word objection because her
Correct.
motion is in reality an objection to garnishment. So you don't want to
Right, so
be granting.
so I'll deny the motion and grant the response, but I'm denying the motion is really the answer.
Yes. Okay, then
Okay.
we'll prepare an order. Thank you, Your Honor.
All right, the order is to follow. I'll let the record reflect, I was not able, I placed the Miss Whitby on mute because she was not allowing the conversation to take place concerning the order. And that's all for the record in 23-02240. Mr. Beck, thank you for your appearance. Miss Whitby, you should be all set. Thank you for your appearance.
Thank you.
All right. All right. All right, so we're back on the record in 25-04295. That is JP Morgan Chase versus Brook Ridge. And Mr. Price, did you have the opportunity to speak with Miss Ridge in a breakout room?
Yes, we did, Your Honor. We weren't able to come to any sort of resolution or anything like that. I don't want to totally speak for her. She can tell you the same thing, but she's let us know that she is planning on filing for bankruptcy at this time. So I think we would just ask for maybe like an adjournment. We'll let the court decide how many days you think are necessary there. Just an adjournment for her to do that if she decides to, and then if something happens where she doesn't end up filing, we can still reach out, potentially work something out.
Is that a fair statement, Ms. Ridge? We're looking to adjourn the matter so that I think the paperwork will tell itself once you file bankruptcy, we get an order that indicates that you filed for bankruptcy, and then this lines up all your creditors. Is that what we're looking for today, Ms. Ridge?
Yes.
And Mr. Price?
Yep.
All right. So I would think an adjournment 30 days out would suffice, if not 4 to 6 weeks. Is that a fair statement, Mr. Price?
Yeah. It's actually, honestly, it would be more how long Miss Ridge thinks she would need, but whatever.
All right,
you want to say.
Miss Ridge, we're willing to adjourn it out 30 days, but you should prioritize. If you plan on filing for bankruptcy, I think we all need to know that.
Okay.
All right, we'll adjourn for 30 days out. We're in that vicinity. If we're a little longer, that's because we're trying to work within the court schedule. And we'll adjourn the pretrial to the end of October.
October 23rd at 2:30.
October 23rd at 8:30. Sorry, 2:30. So we'll adjourn the pretrial to October 23rd at 2:30. And then Mr. Price and Mr. Rich, you wait to hear from the litigants if we need that date, or if this has been, if something else has been filed on behalf of Ms. Ridge, which places this in in some type of abeyance. Is that a fair statement, Mr. Price?
Yep. That's fine with us.
All right. Ms. Ridge, we've adjourned this to October 23rd at 2:30. All right, ma'am?
Okay.
All right. Anything else for the record in docket 24-08471, Mr. Price?
Nothing for me, Your Honor.
Ms. Ridge?
No.
All right, you're all set. Thank you for your appearance today.
Thank you, Your Honor. Thank you, Ms. Ridge. Good one.
You too. Bye.
All right, so Mr. Chisholm, you're here for Orbit Leasing.
That is correct, Your Honor.
All right. And then Nikki Howard is here. All right, so we're on the record in docket 2408471. That is Orbit Leasing versus Nikki Howard. This is set for motion for summary disposition. Appearances for the record, Mr. Chisholm.
Good afternoon, Your Honor. Jeremy Chisholm's P74670 for the plaintiff.
And ma'am, you are Nikki Howard, is that correct?
Yes, correct.
This is the time set for a motion for summary disposition. Did you want any chance to meet in a breakout room, Mr. Chisholm, or did you want to go just forward with your motion? That's Ms. Howard, this is a motion to indicate that there are no legal defenses available or there are no legal defenses to the complaint. Mr. Chisholm.
I'm happy to speak with Ms. Howard if she'd like to.
All right. Ms. Howard, would you be amenable to speaking with Mr. Chisholm before the motion in a breakout room?
I don't really have anything to discuss or say. I am working with Clean State of Michigan to file bankruptcy.
Well, that's probably something that Mr. Chisholm should know. But that may indicate whether, but it's up to you, Ms. Howard. You don't have to talk to Mr. Chisholm. Mr. Chisholm can go forward with this motion. It's entirely up to you.
I mean, that's the only thing that I wanted to let the courts know is that I will be filing bankruptcy.
All right. So, Mr. Chisholm, do you want to just go forward with your motion?
Yeah, Judge, I think given the circumstances, I don't think, unless there's some way, and I'd be happy to try, unless there's some way that that we can, prevent Ms. Howard from the necessity of filing. But obviously I can't advise her, or court can't advise her as to whether she should or needs to file. But if she wanted to, work out see if we can work out something that would maybe, mitigate the need for that, I'd be happy to try. But if she's already made that decision and we know that that's what's going to be, then I guess I'd ask that our motion be granted. And then obviously we know that, not to put too much effort into this thing in the post-judgment collection process over the next couple of months.
All right. So the motion for summary disposition is based on the motion that's been filed. Do you have anything to add to the motion concerning the motion for summary disposition, Mr. Chisholm?
I do not, Your Honor.
All right. Ms. Howard, do you have a response for the record to the motion for summary disposition made by Orbit Leasing?
I have a lot to say. I have a lot of responses because they were sending paperwork to a wrong address when I already reported a new address. But I'm just going to file bankruptcy because that's what I've been advised that would be the best option. So. All
right. I'm going to grant the motion for summary disposition based on plaintiff's filing for motion for summary disposition. Summary disposition is verbally granted. If I can spell. This is based on the no legal defense to the motion for summary disposition. And you will follow that up with an order, Mr. Chisholm.
We can do that, Judge. You're on 54A is on my file now, isn't it?
It is.
You guys are okay. We'll get it. Should have been in our original submission, but I don't know. I don't know if your court is wanting us to submit it as an exhibit to the original motion, or
that's a great question. I have submitted the judgment, but I can check after, but it's after trial summary disposition. There is a civil judgment that was sent over, but go ahead and send another one just in case.
Will do, Judge. Thank you.
All right. That's all for the record in docket 2408471. The motion for summary disposition has been granted. Thank you everybody for your appearance today.
Thank you, Your Honor. Good luck, Ms. Howard.
All right. And then Ms. Newbeck, I don't have any further Mr. Smith cases. Did you have any further Mr. Smith cases? Or were you talking to Miss Morgan?
Yes, yeah, it was Miss Morgan.
All right, give me 1 second and I'm gonna call that case in about 30 seconds. All right, so we're back on the record in docket 1700467. That is Lafkew versus Demaria Morgan. This is a motion to show cause. And Ms. Newbecker, did you have the opportunity to speak with Ms. Morgan in a breakout room?
Yes, Your Honor, I did. And we do have an agreement that I'd like to put on the record and also to set a next court date, if I could.
You may. So the agreement terms on the record?
I guess maybe that's probably not the right way to refer to it. Ms. Morgan is going to provide the documents that were requested in the subpoena and order from March 17, 2025. We haven't gotten the documents yet, so she's agreed to provide those documents to us by 2 weeks from today, and by either email or mail. I said she could take a little longer than 2 weeks, but that's sort of the general timeline I want to do. And then to have another to have another hearing date where we can complete the debtor's examination. And I was hoping to get a court date about 30 days out from today to complete the debtor's exam.
All right, so that would be the to see if you're getting all the information you need for the debtor's examination. Debtor's examination. So let me see what is available in that time frame. It'll probably be 30 days, 4 to 5 weeks.
Okay.
October 28th at 2:30.
October 28th at 2:30, and we'll use that as an adjournment date for the discovery request and debtors hearing. So, Ms. Morgan, did Ms. Newbecker indicate anything on the record that was not a part of your discussions?
No.
All right, we've reset this for October 28th. That'll provide some time to see if they receive all the materials they need, and they may be requesting the ending of the discovery hearing, but that's October 28th at 2:30. All right, ma'am?
Okay, thank you.
Is that correct, Ms. Newbecker?
Yes, it is. Thank you, Your Honor.
All right. Anything else for the record in 1700467 is Ms. Newbecker?
No, Your Honor.
Ms. Morgan, do you have any questions of me?
No, ma'am. No, sir, excuse me. Miss Newbecker, just for confirmation, you were gonna send a list of everything I needed, correct?
Yes, we're going to send a letter
Okay.
probably out tomorrow, and you'll get it in the mail
Okay.
at that. And the address you gave me,
323, yeah.
right.
Okay.
Yep.
All
Okay,
right,
thank
perfect.
you.
With that understanding, thank you all for your appearance today. You're all set.
Have a good
Thank
day.
you.
You too.
Bye-bye.